Good morning, everybody, and welcome to Archer's first joint webinar. I am delighted to be joined this morning by Dan Chapman of Leathes Prior. Dan is an employment law specialist, and he's going to be talking to us this morning about IR35 and its effects on the construction industry. I will then be talking to you about the labour and material shortages that we are currently experiencing. Just a little bit of housekeeping before we get started. It should be automatically set to this, but please keep your microphones and cameras turned off for the duration of the webinar. We will be taking questions at the end of the presentation. We've had some questions through in advance, which we will deal with. But if you have any queries whilst we are talking, please do use the chat function and we will try to answer those questions at the end. Just one point to note that anything that you do write in the chat boxes are seen by everybody on the webinar, so please keep it clean. Finally, I'm obliged to tell you that this webinar is being recorded. So I will now hand over to Dan for his part of the speak, and I will see you again shortly.
Good morning all, and thank you, Carolyn, for that introduction. Carolyn is in charge of the technology, so I'm going to be doing my Chris Whitty impressions this morning. And Caroline, if I can have the next slide, please. I would be most grateful. So, as Carolyn says, I'm an employment lawyer, and one of my many peculiarities in life is that I rather enjoy IR35, which is probably a strange thing to admit, but what I'm hoping to do in the 20 minutes or so I've got with you this morning is debunk a few myths and try and just cover IR35 in its most simplest form. I don't know about you guys, but I'm sure you've read and heard lots about IR35. A lot of it is very dull in terms of how it's presented, and it's very complex, and it's often driven by a very much accountancy-led perspective. But in actual fact, IR35, much to the disappointment of accountants and tax advisors, is actually fundamentally a matter of employment law. And I hope none of you on this presentation will be in this position, but if you ever find yourselves up before a tribunal having to debate whether or not your contractors fall foul of IR35, it will be fundamentally an employment lawyer that you will need to turn to. And I want to try and help you guys this morning with some basic understanding of the issues, but also hopefully as it relates to the construction industry, perhaps touch upon some solutions and, as I say, debunk a few myths. IR35 is the colloquial phrase that we all know of. It relates to the off-payroll working rules, which are part of a piece of legislation that actually came into force in 2003, though it didn't apply until 2017 for the first time in the public sector, and it, as I'm sure we all know, now applies to the private sector as of April this year. Next slide, please. So it's an anti-tax avoidance regime, and IR35 is all about HMRC deciding that they're losing lots of money because contractors and the users of contractors are declaring people as self-employed, when in fact HMRC would take the view that they should be employees. And this is what HMRC refer to as disguised employees. Where a contractor uses a company, it may be Dave Smith and he has Dave Smith Limited, and the end user is being invoiced by that company. The legislation is all about determining whether in reality Dave Smith should be an employee. Next slide, please. It's really important, though, to understand what IR35 is concerned with, and I've read a lot of things that are wrong and suggest that its scope is far wider than it actually is. What we're talking about is individual contractors who are operating via a PSC, a limited company, a personal service company. So again, picking on my notional Dave Smith, If he is a builder and he is engaging with you as Dave Smith Limited or any other name of company, that's the first thing. IR35 is not concerned with sole traders. If Dave Smith is a subcontractor and he's invoicing in his own individual name, IR35 is not concerned about that. There are separate issues with that outside of the scope of what I'm talking about this morning. But what we're talking about here is individuals that operate via limited companies. We're also talking about individuals that are resident in the United Kingdom. HMRC have no jurisdiction over contractors who are resident abroad, who are then providing services in this country via a company. In many ways, Brexit and work permits have probably reduced the number of those such individuals. But nonetheless, what we're talking about here is UK-based and UK resident individuals. It's also only concerning the provision of labour inside the United Kingdom. We're not talking about any work that contractors may do in other countries. HMRC, again, have no jurisdiction over that. And finally, and this is important, we're talking about where those individuals and their companies contract with the end user of the labour, yourselves. I'll come on in a moment to looking at agencies, for example, which slightly changes things. Next slide, please. Thank you, Carolyn. There's another important caveat, but again, it's often misunderstood. You may have heard of a small business exemption. And I've had a number of clients say to me with glee, but sadly incorrectly, that, oh, we don't need to worry about IR35 because the small business exemption applies. The problem is that they were looking at the contractor and deciding that the exemption applied to Dave Smith Limited. That's irrelevant. Doesn't matter how big or small Dave Smith Limited is. The likelihood is those companies will be quite small. It's one individual's turnover. The small business exemption is about the end user of the contractor, the companies that are using the labour. But there is an exemption that may help some of you because IR35 applies only to medium and large businesses, and the definition is meeting two of the criteria you can see there. A turnover of more than 10.2 million, total assets of more than 5.1, more than 50 employees on your payroll. If you meet two of those criteria, you are a medium or large business, and unfortunately IR35 applies. If you are part of a group company, you have to look at the overall group finances, and if the overall group meets two of those criteria, IR35 still applies. But if you are a small business, i.e. anything that's not a medium or large business, then IR35 does not currently apply to you. I suspect in future years it will, but it doesn't at the moment. Next slide, please. So assuming you are a medium or large private sector business, if you're in the public sector, then you'll have been doing this, I suspect, for many years anyway. But what you should now be doing from April of this year is looking at all of your contractors that you use. That's any individual that's working for you that isn't on your payroll, and assessing whether IR35 applies. The first question, therefore, is, are they operating via a limited company? Are they resident in the UK? And if the answer is yes, we need to consider whether IR35 applies. Even if you are absolutely confident that it doesn't, you still need to have the documentation to show that you have considered it and you have made an assessment. And there is a document called a status determination statement that you must prepare, where you set out your views in relation to whether that contractor is caught by IR35 or not. Why are we talking about this? Well, the next bullet point there is the key thing. If IR35 does apply, you have a legal obligation to deduct income tax, pay as you earn, and national insurance contributions from any invoices that you pay, any fees that you are paying to your contractor, to the contractor's limited company. I mentioned in the previous slide about this only applying to the end user. If you do not engage with contractors, but you are engaging with an agency, and so you don't have a direct line to the contractors yourself, then you still do need to issue a status determination statement, but it should go to the agency, and ultimately it will then be the agency's responsibility to deal with any tax deductions. That may therefore make one conclude, well, the simple solution to IR35 is to just use an agency for all the contractors. The problem with that is that the agency will want their margin still. It doesn't deal with the issue, because if the agency has to deduct tax and NI, they're in the same position as you would be, and the margin that the agency will add on top will potentially make it even less attractive than if you engaged direct. You also, by law, have to have a dispute resolution procedure in place, because if your contractor disagrees with your assessment on whether they should be in or outside of IR35, there's a mechanism by which they can seek to challenge your views. Next slide, please. So when you're looking at determining the status of your contractors, what are you supposed to do? Going back to what I said at the beginning, this is an issue of employment law. It's not really driven by finance or tax or accountancy. The test is, should this contractor be an employee? Are they a disguised employee? And I'll come on in a moment to how we define that. As an end user, having assessed that status, you then have to decide whether it is legal for you to pay them via a personal service company, and it is legal provided you are deducting tax. I mentioned the medium and large business exemption. It's just important to clarify that if you are a small business, this isn't carte blanche to simply ignore the tax issues, because although IR35 doesn't bite, and there's particular penalties that come with that, there's still general tax legislation which says if somebody should be on your payroll, they should be on your payroll. So if you are a small business and you have contractors that in reality are disguised employees, you can still have HMRC turning up at your doorsteps giving you a hard time. But what you don't have to do is go through all of these formalities of status determination statements, etc., etc. So next slide, please. And in fact, Carolyn, if you could kind of go forward one more. So this is what we're really dealing with. How on earth do we decide if this contractor is a disguised employee? What is the fundamental law behind it? There's been lots of cases on this over the last few years in relation to IR35, but also more generally, because the issue of employment status isn't just an IR35 matter. I'm sure lots of you will have recalled in the news over the last few years, Uber taxi drivers, for example, went to court trying to establish that they weren't genuinely self-employed because they wanted to be paid holiday pay and sick pay and have pension rights. So a whole body of case law has emerged that was considering whether Uber drivers were in fact employees. Deliveroo riders, there's been case law on those. They've actually been held to be self-employed, whereas Uber drivers were held not to be self-employed. So we've had a whole load of cases. There's also been cases on IR35, as I say, and I'll come on to a recent case in a moment. But what all of these cases look at are these 6 factors. They're looking at control. Does the end user have control over the contractor? Now, in the construction industry, I dealt with a case a number of years ago. A very large company had a number of contractors that were working for them for 6 to 9 months on a project. They were very specialist contractors, mostly dealing with sort of quite complicated engineering issues. But the legal dispute there was, did the end user have control over them? And they did, in the sense that they were told to turn up at work at 8 in the morning. They were told what sites to go to. They were told to finish at a certain time. They were told when they could take their lunch breaks. There's a whole set of rules. They were treated alongside the employees, and the end user expected them to behave as senior, well-paid employees. And that demonstrates control. The easy way to look at it is if you engage a window cleaner to come around your house, a genuinely self-employed business, you might say to them, can you turn up at 9 o'clock in the morning? But if they turn up at 9:30, you don't have any legal ability to sanction or discipline them. Their obligation is to come and clean your windows, and they may well decide at what time they're going to do that. Mutuality of obligations is the second test, and this is the courts looking at whether there is a two-way street, essentially. And in the Uber case, it was considered that it was a one-way street. The drivers had lots of obligations towards Uber. You must log in, you must use this app, you must do this, you must do that, you can only drive in this way, you can only charge this, a whole load of rules. But then they looked, what are the obligations going back the other way? What are Uber obliged to give the drivers? And the answer was very little. They're letting them access their app, and that's about it. No real mutuality. Substitution is important in that somebody who's genuinely in business on their own account is able to substitute, send somebody else along. A window cleaner could say, I can't clean your window this morning, but my colleague is. You're not going to care so long as your windows are cleaned. Is a self-employed person too integrated into your workforce? If they are, that's a factor that will point to disguised employment. By integration, I mean things like if they have an email account, they're on your website, they're on LinkedIn, they look like one of your employees. That's too much integration. HMRC, fifthly, are looking for evidence that they're carrying on business in their own account. A self-employed person is in business. Have they got a website? Are they marketing for clients? If they're not, why not? Who sets up a business and doesn't advertise it? And a lot of contractors are falling foul on the fact that they have no evidence at all that they're seeking any business. And that's always a big problem. And then all the usual factors consistent with employment relationships, sick pays, holiday pays, giving people company uniforms. HMRC are looking at all of that. You, as the end user, have to look at all of these factors with your contractors and complete your status determination and decide whether you think this is a disguised employee or not. Next slide, please. So the starting point for carrying out such a determination is an online tool. I'm sure some of you have seen it. HMRC have this. It's called Assess Tool. And you can answer all the questions and it will give you the view on whether this person is in or outside of IR35. If you enter the information correctly, then HMRC is bound by the result. So it's a useful thing to do, but please don't rely on it. It is not in itself perfect. The questions are pretty rubbish. They're pretty vague, in particular in respect of obligations. And just to illustrate the point, a government department one floor down from HMRC in Whitehall, Department of Work and Pensions, used the Assess tool, decided that their IT contractors were not disguised employees, and HMRC disagreed with them and fined them £87.9 million for breaching IR35. So one government department couldn't even get it right using the other government department's system. So I would say this, but if unsure, take legal advice, please. Next slide. So just quickly, some specific considerations for you guys in your industry. Next slide, please. Please, if you haven't already done so, look at all of your contractor arrangements and make sure you have made the status determinations. And where you are nervous and where you think you're taking risks, please take advice. The bottom circle there to the right is key, because it's vital to consider, can we afford to, or can we attract any of these contractors on an employment basis? Can we employ them part-time, full-time on a 0 hours contract? Can we make the numbers work? If we can't make the numbers work, what impact is that going to have in current and future projects? What discussions do we need to have with our contractors? What level of risk are we willing to take on this? Next slide, please. It's very important from HMRC's perspective that if they see someone is being paid on a project-by-project basis, that tends to be a strong factor towards genuine self-employment. It's not always possible, but again, using a sort of an obvious example, if I engage somebody to build me a summer house or a conservatory, I'm going to agree a price for the job. I'm going to agree to pay them £50,000 to do that job. I'm not likely to pay them by the day or by the hour. Unfortunately, a lot of contractors in your industry, I'm very aware from clients I act for, are paid by the hour or by the day. By the day is better than by the hour. By the hour is the least favourable route, because HMRC will immediately think hourly paid means 0 hours contract employee. Make sure your contractors, if you are accepting them as contractors, are running their own business, and make sure there's things that they have done to show that. Make sure they've got a website, make sure they have their own equipment, make sure they have their own business insurance, make sure they go on training courses. And using my Dave Smith example, for heaven's sake, tell them to not call their company Dave Smith Limited. It's far too obvious. HMRC are searching on Companies House for companies that are the same name as the individual. So it's just an obvious thing to not do, and try and make sure that they're not too integrated into your company and that there's sufficient separation. Next slide, nearly finished. HMRC are already conducting compliance checks. Despite the law coming in April 21, I had thought HMRC's priority would be furlough fraud investigations, but they are already underway on IR35. The good news for you guys is that at the moment they're focusing on oil and gas and financial services. I don't know where they'll go next. It could be construction, it could be IT, but they have investigators out and around the country already. What is the risk for you? Well, the risk is, of course, that you have to pay the income tax and NI that you didn't pay on all of the invoices that you have paid, but it's worse than that. Not only do you have to pay that tax if you have been found to have fallen in breach, you will also be penalised. And if they conclude you have failed to take reasonable care, the penalty will be up to 30% of the tax. If they think it was deliberate, and you knew what you were doing, then it can be up to 70% of the extra tax. And the next and final slide, please, Carolyn, goes without saying, if you haven't already audited your working practices with your contractors, you need to do so as soon as you possibly can. Make sure you go through the assessment process, complete the status determination statements, take advice if you're unsure, and if you think you do need to deduct tax from your contractors' invoices, then before you do that, think about how we're going to talk to them, involve them in the problem, see if they can come up with some solutions as well, or try and help them reorganise their business so that in fact they are in business and that they can fall outside of IR35. And that's probably the thing I want to leave you with, is that with a bit of goodwill and a bit of cooperation, I'm finding that there are ways of really mitigating the risk, but it requires everyone to really talk and work together and keep records of everything, so that if HMRC do come after you, you can show that you thought about it. And even if you did get it wrong, the penalties will be far less if you can show that you really thought about this rather than just ignored it. I'll be here to answer any questions at the end, but otherwise that's me done for now. Thank you very much for listening.
Thank you very much, Dan. I am now going to be talking to you all about labour and material shortages for the second part of this webinar. So just briefly, for those of you who don't know me, my name is Carolyn. I am a partner here at Archer. I specialise in construction disputes. I've had numerous conversations with clients over recent months concerning labour and material shortages. Unfortunately, there's no easy fix, but hopefully the talk this morning will help you understand what to look for in your contracts and also what you can do to protect yourself moving forward. So just to summarise what I'm going to cover this morning, firstly, how we got here, how the standard form contracts actually work, what the typical position that we are finding is, what you can do with your ongoing contracts, what you can do with future contracts, and also the general market position that we are seeing. There are also some rather unusual photos in my slides. I have to say I didn't put them there. That is down to our senior partner, Andrew Rush. For those of you who know Andrew, that will come as no surprise to you at all. I will let you try and work out the tenuous links as we go forward. So how did we get here? The current situation can be described as a perfect storm. A perfect storm is defined as an especially bad situation caused by a combination of unfavourable circumstances. And for those of you interested, I had a quick look at where the phrase came from. It was coined from a 1997 novel called The Perfect Storm, about a shipwreck which was contributed to by a monumental storm. So a relatively new phrase. How did we get to our perfect storm? Where to begin? There have been so many factors over the last 18 months. The most prominent issue really is the fact that demand currently is greatly exceeding supply, and obviously where demand exceeds supply, prices rise, and in these circumstances they have risen sharply. The real demand issues have arisen predominantly because not just in the UK but worldwide, governments have been trying to kickstart economies following the worst of the lockdown that we experienced by restarting construction. Combined with that, obviously, a lot of construction projects that were underway were suspended for a period of time during the worst of the lockdowns, and they have started up again. Also, in combination with this, there's been an awful lot of residential projects that are underway, largely as a result of people now working from home most of the time and wanting to do so in a better living space. Combined with this, the second biggest problem really has probably been as a result of the shipping delays. So as I'm sure you are all aware, the Ever Given ship got stuck in the Suez Canal for 6 days in March this year, and it caused a huge backlog of delays in shipping worldwide. This combined and contributed to a lack of available shipping containers that came as a result because of not only the shipping delays but also the increased demand for materials worldwide. And the combination of these factors has caused shipping prices to dramatically hike. In addition to this, we've had Brexit, of course. Brexit has caused not only saturated ports, lack of lorry drivers, additional problems with getting materials into the country, but also has caused labour shortages through people either leaving the UK or some people that would otherwise have came to the UK are now unable to due to various rules over who now has permission to work here. Brexit has been recognised as hitting the construction industry specifically hard because the construction workforce is made up of many different nationalities. Finally, of course, we can't ignore COVID. COVID in itself has been going on now for the best part of 2 years worldwide, and it caused initially a huge labour shortage during lockdowns, and then following that there were still labour shortages arising from self-isolations and, of course, the more recent pandemic. So all of those factors have contributed to where we are today. So let's take a look at how the standard form contracts approach these circumstances. Looking first at JCT, material shortages and labour shortages are contractor risk items. That's the general starting position. However, for materials, there is some glimmer of hope taken from clause 2.2. Also, it's sometimes clause 2.3 in other standard forms. This clause provides that all materials and goods for the works shall, so far as procurable, be the kinds described in the ERs. This clause is occasionally deleted, but it often remains. And in practice, it means that if lead times for materials, or potentially if prices for materials have become so excessive that you can argue that those materials are not procurable, the contract recognises that you may need to use alternative materials. That, of course, is only of a benefit to you if alternative materials are available. With regards price increases, the contract sum is based on agreed rates in JCT. And it's worth noting that this includes any variations. So a contractor can be significantly worse off at the moment if a variation is instructed some 12, 18 months after the contract was agreed, because the contractor is required to carry out those variations at the rates set out in the contract. Standard forms do provide for the use of optional fluctuation provisions. However, they are fairly rarely used. I will come on to what the fluctuation provisions actually provide in a moment. JCT also provides for payment for materials off-site and advance payment bonds. Again, I'll look in those in detail in a moment. So firstly, looking at fluctuation provisions, starting with option A. Option A is not really suitable in these circumstances. It is designed to protect a contractor from increases in levies and taxes. So the option provides that for labour, if there is any increase in the levy or tax, which increases the employee costs to the contractor, then that increase will be reflected in the contract sum. Now it's based on the contractual base date, so it's any increase after the base date. And similar for materials, again, any increases after the base date, but the increases focus, or I should say the differences focus on changes to import taxes or disposal of material taxes. Now, if this option is selected, it has to be passed down the chain to subcontractors so that subcontractors get the benefit of it also. It is proffered as the JCT default position, but as I said, fluctuation provisions are rarely used at all in practice, and this is often crossed out. This option will give some protection at present if, for example, taxes are increasing as a result of Brexit, but primarily it's of limited assistance at the moment where the key increases being suffered are through material prices. Sorry. Just to go back to that slide, I should also have said, for anybody wondering, that photo is a Chevy, the link being Chevy to the levy. So, option B. Option B is not appended to many of the standard form contracts, but that doesn't mean that it is not available for use. It is still referred to in the contract particulars as being an option available for selection. The reason it's not appended to the standard forms is, I suspect, due to the fact that it's simply never used. Having said that, option B is the most suitable option for contractors to give maximum protection in the current circumstances. So option B provides that for labour, if there is any increase by a wage fixing body after the date set out in the contract as the contractual base date, that increase will be reflected in the contract sum. So the contract sum will be adjusted to take into account that increase. Similarly, for materials, if there is a change to the market prices after the base date, the contract sum will be adjusted to reflect that change. Now, this option requires a complete open book approach because a contractor will need to prove its costs in order to gain any adjustment to the contract sum. This option also has to be passed down the subcontract chain so that subcontractors can get the benefit also. It's also worth noting that this doesn't just cover increases, of course, and so if there are decreases following the base date, the contract sum can be adjusted downwards. Now, the picture there is of a market that is intended to link to the fact that the change is based on market prices. Finally, option C. Option C also allows for adjustment of the contract sum. It is based on specific formulas. Now, option C is very complicated. The formula changes depending on the specific work type being carried out, and there are over 60 work types recognised in the various formulas. There are additional rules for items manufactured outside of the UK that are imported for direct incorporation into the works. And if you want to use this option, you have to list the articles in the contractor's proposals with their price and any tax payable, and then that is adjusted accordingly. Post-Brexit, this option can give some benefit to contractors. However, it is incredibly complicated, hence the photo of Einstein. You need to be Einstein to understand it. Moving on then to NEC. There's no automatic right to price increases under NEC. The way that NEC contracts deal with inflation is by way of the secondary option X1. So X1 sets out and it enables an adjustment of the price for inflation, and it's done by the parties agreeing a set of indices that apply to proportions of the price. So, for example, a labour index, and then that index is adjusted accordingly. One point to note in relation to NECs is that the key difference is that compensation events, for example, instructed changes, are based on the actual cost at the time of the change. So under NEC, if there is a change, you're not bound to the contract rates that you may have agreed 18 months prior. It is worth noting, however, you should be wary of the requirement to issue early warning notices. Now, compensation events are assessed on the assumption that an early warning notice was issued. If an early warning notice wasn't issued, but had it been issued, the client may have altered its instructions, then a contractor may suffer when that compensation event is being assessed. And the photo there is obviously a BMW X1, which is linked to the clause in the NEC relating to inflation. So, negotiated position. What I've said just now is all very interesting, but what we are finding in practice is that contractors simply don't have protection in their existing contracts for the price increases that we are seeing. So what can you do if there's nothing in your contract to entitle you to an increased contract sum? It's in both parties' interests to ensure completion of the project is viable. So there's often scope for negotiation. Examples of what we have seen being agreed are an increase to the contract sum, extension of time being issued, agreements to waive or reduce liquidated damages, or agreements to accept alternative materials to either reduce lead times or reduce the cost. What will be palatable will obviously depend on a case-by-case basis. And what can you do to protect yourselves going forward? Ordering materials in advance due to increased lead times and fluctuating prices is becoming very common. Contractors shouldn't be accepting all of the risk. Standard forms provide for advance payments for materials off-site, and we recommend that you use these provisions. There's also the opportunity to use provisional sums or prime cost items. This can reduce a contractor's exposure on increasing material prices. I will come on to those 2 points in further detail shortly. Also, the obvious solutions are increasing an LAD-free period. Whilst it doesn't necessarily give much protection in relation to price increases, it will at least give some comfort in relation to extended lead times and damages that contractors may suffer as a result of those. Also, fluctuation provisions, obviously an ideal scenario for all contracts to include fluctuation provisions, but in reality, what we are seeing across the market is that employers are simply just not agreeing to this. So, off-site materials. Just to explain this a little bit further and how it works, under clause 415 of the JCT, it sets out what contractors need to do in order to be paid for off-site materials. Now, the first key point to note is that firstly, off-site materials need to be listed. So they need to be included in the list of listed items, which is attached to the employer's requirements. Employers will then often require proof of vesting. This can be by way of a vesting certificate, and we do sometimes see precedent vesting certificates appended to contracts so that both parties know exactly what is required. Vesting certificates confirm that the listed items are wholly owned by the contractor, and that on payment of those materials, ownership shifts to the employer, despite the fact that materials are still off-site. Contractors will also be required to insure off-site materials against any loss or damage before they are delivered to site. And materials will also need to be clearly marked as being the property of the employer for the specific job that they have been allocated to. Now, an employer may also require an off-site materials bond if payments are going to be made for off-site materials. There is a precedent off-site materials bond appended at the back of most of the JCT forms. Essentially, an off-site materials bond is an on-demand bond whereby the contractor can at any time demand that the surety pays back the money the employer has given to the contractor in the event the materials are not delivered to site. The bond is often capped at an agreed level, which will mirror the value of the materials being paid for, and the bond expires when the materials are delivered to site. Off-site material bonds give an obvious comfort to an employer where they have the ability to recover the monies that they have paid if materials are not ultimately delivered to site. But it obviously does come at a cost to contractors. Having said that, that cost is likely to be far more beneficial than taking the risk of not being paid for off-site materials. And if you're not paid for off-site materials, you then will likely either have to wait longer before they are ordered, and then you're suffering further price increases, etc. Just to note there on the photo, that rather attractive string vest is to represent a vesting certificate. Moving on then to provisional sums and prime cost items. Now, these items are allowed for under JCT, but not NEC. So provisional sums, there are two types of provisional sums, defined and undefined. Now, a defined provisional sum, the works are set out in the programme. So if a defined provisional sum is instructed, you are not entitled to any extension of time. The work is always deemed to be going to be carried out. It's often the case that it is simply still as a provisional sum because, for example, design may not yet have been completed so as to establish a firm cost. Undefined provisional sums are more of a maybe item of work. They're not included in the programme, and if they are instructed, a contractor will be entitled to an extension of time. Now, provisional sums are not valued according to the contract rates. They're valued on a fair and reasonable or cost plus basis, and therefore putting items into a contract as a provisional sum gives a contractor some comfort in that they will be entitled to be paid a reasonable sum for that item rather than it being tied back to the initial contract rates. Prime cost items are an estimate of a cost of an item. So prime costs traditionally do not include the works costs to carry out that work. It's simply the item. So they tend to be used where, for example, an item hasn't yet been selected. But again, with prime cost items, they're valued on a fair and reasonable basis. So a contractor is not linked, not tied back to the contract rates that were agreed potentially some time ago. So it gives the contractor cost protection for increased material prices. Finally, I just want to take a quick look at the current market conditions. As ever, no one is really in agreement as to who should be bearing the brunt of the current circumstances. Subcontractors and suppliers are generally in the best position. We are seeing that fixed price contracts are still the norm, but with additional negotiated extras. So many of our clients are able to negotiate off-site payments and advance payment bonds. So some other examples of what we are seeing at the moment in the market, there's definitely been an increased use of the pre-contract services agreement stage, well beyond its intended design phase. We're also seeing increased use of letters of intent to allow really for pre-ordering to try and fix key material prices. We've been seeing deals fall apart after months of negotiation because, for whatever reason, projects may not be viable for one or another party. We're also seeing some more practical problems for clients, such as storage problems or where materials are ordered way in advance and then additional materials are needed. There may be batch problems. And also potentially damaged materials that are not being discovered for months and months. It remains to be seen what 2022 will bring. So that is the end of my part of the talk this morning. We just have a little bit of time for questions. We have had 2 questions in advance. I'm first going to hand over to Dan to deal with the IR35 question.
Oh, and what was the question, Carolyn?
Oh. I don't have it written down. I believe it was about workers outside of the UK.
Yes, I think we had a question about the extent to which IR35 applied to contractors that you were bringing in from abroad, and I think I did touch upon that in my slides, but to be very clear, if I have a client that has a lot of contractors that are coming over to do a specific project from abroad, they're not tax resident in the United Kingdom, and therefore it's not an IR35 issue. In theory, it is still an issue in 2 ways, so it requires some thought. Firstly, there is the immigration position, and I'm aware of a company that's got into a bit of bother because to get around the employment work permit position, they're labelling people as contractors inappropriately. So you can still have a Home Office issue, and you still have the general HMRC position, which is that if these workers should be employees, you still run the risk on a payroll audit of some problems. But IR35 doesn't apply to foreign contractors in its true sense. Thank you, Carolyn.
Thank you. The question that I have had in relates to force majeure provisions under JCT. So the question was, can we rely on force majeure to get an extension of time in situations where delivery of materials is causing us delay? It's an interesting question, and it is something that I have discussed on many occasions with clients over the recent months. Force majeure is legally accepted as effectively meaning impossible, and so as a primary answer, it is unlikely that delays to materials would be deemed to be force majeure, and the situation can be likened to the situation when the Suez Canal was closed in the 1960s, and the courts at that time found that despite the closure of the canal causing delays to numerous construction projects, it was not force majeure because it didn't deem completion of the projects impossible, it simply caused delays. Now I can see that flies against the general industry position at the moment in relation to COVID, because COVID is generally accepted to have been force majeure, and whilst there haven't been any strict test cases on it, the industry has generally accepted that COVID delays do entitle contractors to an extension of time, but not loss and expense. But I think generally in relation to material delays, it probably wouldn't be force majeure. That said, if you do have strict condition precedent clauses in your contracts requiring you to notify of delays, my advice would still be in all circumstances to notify of delays within the timeframes stipulated in the contracts, because you will be in a far better position to negotiate at the end of the project if you have notified of delays, even if you say it is as a result of force majeure, then you would be if you had lost your rights entirely because you haven't simply notified. So that is that, and I don't believe we've had any more questions. Let me
one in the chat room, Carolyn, from Nigel.
Is that I can't actually see the chat room? Is that for yourself or for me?
No, it's for you. I can read it for you if it will help. It says, how does industry-wide concrete shortages apply / work under 2.2 of the JCT procurability provision, please?
Yeah, so it's a difficult one. Ultimately, with clients, they've been having to negotiate the position with employers. There's an industry-wide problem, obviously, with concrete, and there's a lack of other available materials that can necessarily be used. But on a case-by-case basis, it is always worth raising the point if it is causing severe problems in any contract, if you think there is an alternative that could be used, and to raise the point that you deem the concrete to not be procurable in accordance with the contract, and that the parties are required to agree an alternative and see ultimately what can be agreed. Okay, so I think that is everything. Thank you very much, firstly, Dan, for joining us this morning. Your talk was very informative, and thank you everybody for participating. I hope you enjoyed this morning. Obviously, if you have any further questions, do feel free to get in touch with Dan or myself. We'd be happy to help further with anything as necessary. And that's about it. Thank you.
Thank you very much.